Hello. When somebody dies, unfortunately, his heirs or her heirs do not become owners of the property of the deceased person right away, contrary to what many people think. And there is a reason for that. Let's say you're an heir of your late parent, spouse, uncle, whoever, and once you got the information that now you're the heir and that person died, you started to manage the property, to dispose of some of it, to pay some debts, and to use the money. And then at some point, you might realize that the debts of the deceased person are greater than his assets or her assets. And then you're in trouble because now you will be personally responsible with all your property for the debts of that person towards all the creditors, be it the government, the banks, buyers, business partners, whoever. To avoid that, there is a middle body in law, like some kind of a limbo for the property, where once somebody dies, his or her property becomes the property, the assets, and the debts of the estate or succession of that person. It's sort of a company, but not a company. It's a legal entity with a liquidator or executor or trustee or administrator at its head. The sole purpose of which is to collect all the assets, to discover all the debts, to pay the debts, and then deliver the assets to the heirs, like free of any debt already. At some point, it might be if the liquidator or liquidators find out that the assets are lower than the debts, there is some time for the heirs to consider if they want to renounce their rights in the estate and the succession so that they won't be responsible for the debts. When finally the liquidation is over, that would normally mean that all the debts are paid, all the responsibilities, all the obligations are fulfilled, and now the rest is clean to be distributed to the heirs. That's the idea. Very often, the person who is normally one of the heirs, but not necessarily, that person still is in a position of a liquidator. And if that happens, that person might mix it up in his or her head and start to deal with the property, with the assets from his or her position as an heir. And that would be a mistake because it's the liquidator who is responsible. And again, if the heir starts to do something like that, that heir might become personally responsible. So, how one becomes a liquidator? If the person died without a will, then there are heirs by the letter of the law. And those heirs might get together and elect a liquidator, executor. If there was a will, then usually the name of the liquidator is there in the will. And that's how then the liquidator would be appointed. The wills might be of three kinds. One, in Quebec at least, it's a notarized will, and then it's valid as it is. The second is a handwritten will. The third is a will signed before witnesses. With the last two, before even proceeding with anything written in that will, you need to probate them in court to obtain the court's verification and approval that this is an actual valid will. Once you have that, then the name of the liquidator normally should be registered in the register of real personal movable rights, at least in Quebec again. And after that, having the will, probation decision, if necessary, the death certificate, and this registration, the liquidator might finally start to contact the insurance companies, the banks, the government in the name of the estate. Open the account of the estate, transfer the money and whatever the assets to that account, if possible, transfer the removable property in the name of the estate, the titles, and so on and so on. So once that work is started, the responsibilities, the obligations of the liquidator start to amass, and there is a significant room for a mistake and for responsibility before the government, before the creditors, and before the heirs. And please note, not only before the heirs, creditors, including the government, are also there. So if you think that you're not up to the job, if you don't want to do it, if you're not close, maybe you're somewhere abroad, if you don't have time, if you don't have resources for that, the good point to renounce the office would be even before you started doing something, because once you have started, there is responsibility. Okay, so what do you do after all the formalities? Well, you collect the assets and you find out who are the creditors. They might be banks, might be business partners, might be some other people, definitely the government with respect to taxes, maybe something else, maybe some child or spousal support is owed to somebody, so on and so on. So once you collected all that information about the assets, about the debts, maybe did some evaluation, compared them to, you are ready to provide preliminary or even a real one, an inventory of the assets. And you have to provide that to the heirs. That's one of the very first and maybe greatest responsibilities, well, after searching for a will and probating a will if necessary. There in that inventory, you basically show what's the balance. And if it's positive, if the estate is solvent, is one thing. If not, that's another. That's why usually the Civil Code of Quebec gives you something between 6 and 8 months to do all that, so that the heirs would have time to see what's going on and to decide for themselves if they want to continue to be heirs or if they want to renounce. So at some point, it's all there. You have the bank account for the estate, you have information of what's going on, you have compiled the inventory, registered the inventory, provided it to the heirs. So your next step is to pay debts, whatever they are. And your responsibilities as of any administrator of property of some other person. So you cannot simply decide whatever you like. You cannot do it as you please. You have to think what will be in the best interest of the estate. So you want to pay debts, but only to the extent where the debts are payable, and maybe even go to court if needed to protect some rights and to fulfill some duties in a limited manner. You want to collect everything that somebody else owes to the deceased person and now to the estate. You cannot simply just dispose of some valuable property and give it even to the heirs and even to yourself as an heir, because at this point you're just guarding the property for somebody else, for the heirs. Again, even if you're one of them. So you proceed with paying debts, and if there is not enough, you even might go for bankruptcy. But let's say it was enough, So you paid it all. You obtained all the documentation, all the proper documentation that the debts are paid, including the clearance certificates from the government, and then you proceed with delivering shares to the heirs. First, you go with those who are called heirs by particular title, meaning that somewhere in the will, the deceased person, the testator, then said that, okay, this particular vase or this particular portrait or my collection of hunting tools or whatever, or my car, I specifically because leave to that person or to that person, or my stamps collection, or my old wine, or my house located there and there. So when the property is clearly indicated as going to somebody, that's the situation of a particular title, bequest by particular title to a particular person. So that's sort of like the debt of the estate of the second rank after real debts. Once that is delivered, everything else is distributed either to universal legatees, meaning to those to whom everything else was left, or sometimes to legatees by general title, meaning that there were particular shares, like 12% to that person, 18% to that person, and so on and so on. Let me remind you that those percents, this percentage, is calculated from the amount left after all the debts are paid and after the bequest by particular title delivered. You might ask, like, what happens if the estate might become insolvent if their bequest by particular title are delivered, if the property delivered to heirs by particular title? Then the property, the value of the property to be delivered to them is diminished up to the situation when those particular titles might be even cancelled. Usually, for that, you have to proceed very cautiously. Often, you need even to go to court again, or at least definitely consult a lawyer, because you're protecting your own responsibility as usual. And you're okay if during all this process there is no conflict among heirs. Because if there is, and if some of them think that you're playing in favor of the others, then they might be claim against yourself. And again, the best protection is that you keep all the paperwork, all the receipts, all the documentation of every step. You can make account for every penny spent or received. So it might be hectic and stressful, but still feasible. Yet another time, while listening to that, you might think if you really want to go there. But again, it's possible. So then, when it's finally done, you have to produce your final report to the heirs, just showing this what came to the estate, this what was paid from the estate, and this is what was left and distributed to the heirs. And if they approve that final report, then basically your job as a liquidator is over. If they don't approve, though, you might again need to go to court and obtain a court's authorization for that final report. And that's enough for today. We'll continue with that topic later. Thank you. Have a nice day.